Good morning, Your Honor. May it please the court. My name is Muhammad Hafiz bin Hamzah, counsel for the appellant Billy.
Assalamualaikum and hello to Your Honor. May it please the court, my name is Muhammad Ashraf bin Mansur, counsel for respondent Lily. This case about a make a counter offer from plaintiff Billy to defendant Lily.
Whether the contract between Lily and Billy is valid, void or voidable because Billy made a counter offer. Contract between Lily and Billy is void because Billy accepted the offer on condition that Lily will repaint the car. The offer is a response given to an initial offer. A counter offer means the original offer was rejected and replaced with another one. The counter offer gives the original offer three options: accept the counter offer, reject it, or make another offer. Section 7b, acceptance must be absolute in usual and reasonable manner as prescribed by the proposer.
Your Honor, ladies and gentlemen of the jury, this case is whether the contract between Billy and Lily valid, void or voidable because Billy made a counter offer. Contract between Billy and Lily is valid because Billy said he willing to accept Lily offer without any condition. Make a counter offer is not listed in Act of Contract 1950, but this method used to counter offer from customer to reseller. Let me explain in section 39(1), where a promiser has made an offer of performance of the promise and the offer has not been accepted. The promiser is not responsible for non-performance, nor does he terribly lose his rights under the contract. As a consequence, we can see that Lily is not interested to sell her car to Billy because Billy made an offer with a condition.
Based on the case Hyde vs. Ranch, 1840, 49 ER 132, the defendant offered to sell a farm to the claimant for 1,000. The claimant in reply offered 950, which the defendant refused. The claimant then sought to accept the original offer of 1,000. The defendant refused to sell to the claimant and the claimant brought an action for specific performance.
According to Inides v. Bell 1913, the parties in this case agreed to use the post as means of communication. The defendant made a proposal to sell his piece of land to the plaintiff, and the option to purchase must be exercised on or before the 20 August 1912. The plaintiff sent his acceptance by registered post on 16 August 1912, but it was not delivered to defendant till 25 August 1912. Had to this case, applying section 4, communication of acceptance was complete when the notice of acceptance was posted on 16 August 1912, even though the defendant did not about the acceptance.
In conclusion, the contract between Lily and Billy is void because Billy accepted the offer on condition that Lily will repaint the car. A counter offer is a response given to an initial offer. A counter offer means the original offer was rejected and replaced with another one. The counter offer gives the original offer three options: accept the counter offer, reject it, or make another offer. In section 7b, Contract Act 1950, acceptance must be absolute in usual and reasonable manners as prescribed by the proposer. The case Hyde vs. Ranch, 1840, 49 ER 132, the defendant offered to sell a farm to claimant for 1,000. The claimant in reply offered 950, which the defendant refused. The claimant then sought to accept the original offer 1,000. The defendant refused to sell to the claimant, and the claimant brought an action for specific performance. Thank you, Your Honor. I hope you will make a correct decision.
My final decision, defendant Lily is innocent in this contract. This is because the contract between Lily and Billy is valid because we can see that plaintiff is willing to accept Lily's offer without any condition. I asked the court to review all the facts and evidence proving that my client did not violate the law. Thank you, Your Honor.